So this webinar is going to be regarding the Federal Employee Retirement System disability retirement. There are a lot of aspects to retirement. We have to narrow it down to a 1-hour topic, so we will only be discussing disability retirement at this webinar. So if you have any questions, I know that there were some set ahead of time, but if you have any questions as I go, please limit them to disability retirement, just so that I can get as much detail for those who are interested in this process or need help. We can target those areas. We will discuss at the webinar today eligibility requirements for FERS disability retirement, the application process, as well as the appeal process. So, you know, a lot of times we get decisions, where can you take those if they're not in your favor, and how far can you take those? I'll also along the way remind or inform you of any type of deadlines that you might have as we go. If we can go to the next slide. So like I mentioned, this is about the Federal Employees Retirement System. That's FERS, F-E-R-S. There is also, if you're an employee before 1987, you might be as part of the Civil Service Retirement System, or CSRS. That has a few different requirements. I'm not going to be covering that in this webinar, but generally speaking, they overlap in a good amount. But I will be speaking specifically to the requirements and eligibility for FERS employees. If we can go to the next slide. So eligibility requirements for disability retirement under FERS. I will be very, very detailed. This is not Social Security disability. So there is some overlap in kind of the proof requirements between FERS disability retirement and Social Security disability. However, the regulations are very different, as are what are you required to show. So eligibility for FERS disability retirement is you have to have had at least 18 months of credible service for if it's your position for the federal government, you need to have at least 18 months. I think immediate retirement, in order to vest for the federal government, it's 5 years. You do not need 5 years for disability retirement applications. What you do need to show is while you are employed. So that's a very important piece. While you are employed in a position subject to FERS, which means you're paying into the FERS retirement system, you must have become disabled from providing any type of useful or efficient service, is the specific terms. This just means that while you have been working in your position, your disabling condition, whatever your disabilities may be, mental or physical, prevent you from actually performing any of the essential functions of your job. So this could be if, say, you do significant amount of typing and you have arthritis or carpal tunnel in your hands, and it has progressed so much to the point while you've been employed at the agency that you're working at, you can no longer type for longer than 5 minutes at a time before needing to take significant breaks, or you can't move your hands at all. Things like that. It has to be whatever your disabling condition is, it has to be directly tied to essential functions of your position. The third thing is that your agency where you work must be able to certify that they're unable to accommodate your condition, whether that's specific, whether your doctor has made specific recommendations, or you have made specific recommendations. Any type of accommodation that's volleyed back and forth, your agency says they can't do it. If you've been previously accommodated, this could also come in the form that you have asked for additional accommodations because the pre-existing or the granted accommodations are no longer successful, or they're no longer enabling you to work. And that's really what this certification is about, is that there's nothing the agency can do legally or without an undue burden to themselves for you to be able to continue working. A lot of the times the accommodation process, which is a little bit separate from this, there's medical documentation, there's support from your doctor that you might have to obtain and submit to the agency to tie this up, but you do have to show that you did request accommodations and that the agency cannot accommodate you. To be a little bit clearer on this point, light duty, any type of modifications of that nature is not necessarily an accommodation. That's where, it's a temporary fix per se. So you will have to show, not only light duty, but is it possible that you cannot be accommodated if you were to return to your position? There is also a progression of it. So if you cannot be accommodated, if light duty is no longer possible, and your agency is now looking at reassignment. Reassignment is kind of, I've heard it termed as the accommodation of last resort. So if you can't continue to perform your essential functions of your current role, the agency will go through the process of reassignment. This is where they might ask for a resume. They might ask for details, what are the bounds of your accommodations? What can you and can't you do? And then they will ask you for other parameters, like what duty locations are you willing to travel to? Are you willing to travel 30 miles away from your home? Is it fully remote? Do you need to work full-time telework? Those types of things, they'll ask you to set those parameters, and then they'll do a search of any available positions at the agency. Those positions will include what your accommodations are. They're supposed to take into account what essential functions you cannot perform anymore, so that should be a different type of position. So say you're a law enforcement officer, it might be an administrative position, something like that, where it's taking account what are your actual disabilities and what can you do. If you do this reassignment search, the agency does have to certify this as part of the forms. If you do the reassignment search, I believe they have between 30 and 60 days to do some sort of search and give you the information. So if they turn up that there's no possible reassignment, that's helpful for a disability retirement application in two ways. It shows that there's no eligible position, meaning you can't transfer somewhere, you can't continue working. The agency has done all that they can to help you continue providing efficient service for it. It also shows that that your position has progressed to the point, obviously, where you can no longer work in that position, and it shows that sorry, I lost my train of thought there. It shows that you are no longer eligible to work in that position. It shows that the agency has done all that they can to accommodate you, and it supports the fact that you are applying for disability retirement as a last resort from that. A lot of individuals who are considering disability retirement, they are to a point in their career, they don't want to do this, right? Nobody wants to take Social Security disability. No one wants to take disability retirement. They want to become, they want to continue working. They want to, that type of value a lot of people find in positions and jobs and working. So a lot of the times going through those processes helps the applications. It shows that you have tried everything that you can. With reassignments, again, it's all voluntary. So there are times where your agency might come back and they might say that there's an available position for you to take. But it might take, if you take it, it might result in $30,000 less salary. Things like that are weighed on a case-by-case kind of basis with a disability retirement application. Is it reasonable for you to turn down a job, a reassignment, where the only one available to you is a position which would be a significant pay cut or even a GS, a grade level decrease? So that's not necessarily a deal breaker in these applications, but something to keep in mind is a possibility where you could go through all of this, you could ask for a reassignment, and they could find you a position. And what are you willing to take? Do you want to continue working? What are the pros and cons? The one thing to keep in mind with reassignments, if you do take a reassignment, it is a permanent reassignment. So as part of this process, you are transferred to a new position that is now your position of record. You cannot then thereafter file for disability retirement from your prior position. So going back to the example of a law enforcement officer, say you are a law enforcement officer, you ask for a reassignment and you're transferred to an administrative assistant, whatever the total title may be, but the position is completely different than what you had previously held. Say you hold that position for 2 months and your disabilities prevent you from doing those essential tasks. If that's the case, your application for disability retirement is from the administrative assistance position, not from the law enforcement position. So if you are not sure if you will be able to perform the essential functions of the position you're being transferred to, if there is any hesitation in your mind, I would not recommend taking it, just from the standpoint of there's a risk that you would then have to meet all of these eligibility. You would have to prove the accommodation portion. You would have to prove that your disability is progressed to the point where you cannot perform essential functions of that position. And obviously, if you take a pay cut, and we'll discuss how this is computed, that will obviously have an impact on what kind of benefits you could get for disability retirement or later regular retirement. So many things to consider on that point. The final point here is an application must be submitted within 1 year of the date that you separate from the federal government. Whether you resign voluntarily, if you are removed for any reason, or you simply just you no longer are working at all. You're in no working capacity, and you are separated from the federal government. You have 1 year. It's very important to remember this date, because if it's anything over a year, there are exceptions, but they are very difficult to prove. It is mental incompetency. It is you didn't receive some paperwork delay, and maybe the timing of your separation is in dispute. But there are very, very minute cases where it's approved for something over 1 year. It's very difficult. You have to jump through a lot of hoops. So it's kind of one of those situations where if you can get it under a year, if you remember that date, that's the best case. It saves you a lot of headache, a lot of stress, and a lot of time going back and forth with OPM just to have them review your application. If you are still employed or within 30 days of leaving the federal government, you do have to apply through your current or former agency. There are, at each agency, there's specific HR divisions that process these applications. You send in the forms and everything to them. They fill out what they need to, and then they forward it on your behalf to OPM. If you have been removed or separated from the federal government for more than 30 days, you apply directly to OPM. In those instances, you should make an attempt to get the required forms from your former agency, but OPM will also make a request for those forms from the agency as well. If we can go to the next slide. So the application process for disability retirement. There are many aspects to it. There are required specific forms. There's the SF3107, which we included a link here on the slide, as well as the SF3112. The SF3107 is just for regular retirement. This is something that everybody fills out, depending on if it's immediate or disability. A lot of it's more like personnel information. So who are you? What's your direct deposit information? Your spouse? Do you elect to have a survivor annuity? All of those things are more on that form. That form as well has a few things that the agency has to click through. So I would say there's about maybe 3 or 4 pages of information that you are responsible for as part of that form. The SF3112 is specific to disability retirement. It gives small boxes for you to fill out and describe your disabling condition, how it's disabling, accommodation efforts, things of that nature. Often we are attaching statements to the back of this SF3112, describing in a little bit more detail, as is usually necessary, what medical conditions are diagnosed, when, the history, how they've progressed. You want to be as detailed as possible in these applications. As part of the SF3112, there's also forms that your supervisor is required to complete, as well as the accommodation efforts that we discussed a little bit earlier, that the HR department or whoever the designated official is at the agency will need to complete before they send in. Your supervisor statement is more of a attestation to when they notice that your performance, your conduct, your attendance is no longer sufficient. So they're weighing in, giving a date, as well as the things that they've noticed. Again, these are just fillable boxes. And your supervisor can consult with you. He can consult, or he or she could consult with HR or the legal department on how best to complete that. But there is a portion where the supervisor is involved. And it's best to try to, work with them if you can, or they're willing. It's best to work with them to really fill out that form to help you the best as possible. In addition to these forms, you will need to submit medical records. This is very important. So OPM is considering not only the subjective evidence, which is your statements, your supervisor's statements, if you can, family and friends, if they're able to write something up about what they've noticed about your medical conditions. Have they gotten worse? Do you no longer want to play with your kids? Can you no longer go to family functions? Do you no longer go to happy hour? Those kinds of things, that's subjective evidence. All of that is considered and weighed in the application. The real meat of the application, though, you need some medical support. So this is objective evidence. This can be visit summaries. It can be a doctor letter, which is the best case scenario. And it can be other types of opinions or clinical findings. So sometimes individuals go to get psychological assessments, or if you work for the FAA and you're an air traffic controller, you might have where you go to occupational health and you do those types of assessments every so often. You might be subjected to medical clearances for your position. Those kinds of things all play into the medical records that you can submit and that OPM will consider as part of the application. The things that you want to look for in your medical records are making sure that your doctor is matching up in the medical records exactly what you are aware of for your condition. Oftentimes doctors do shorthands, they don't fill out these medical records as sufficiently as they should. So you might have to make sure your doctor corrects things into the records. You will want to review them before you submit them to your agency or OPM. Don't just assume, what you know of your condition, your doctor has allayed properly in your medical records when you request them. You are under no obligation as part of this to submit like a medical release to the agency or OPM. You are providing the records to them. They are not, in most cases, they're not going to contact your physician, though you can sign forms if you want to, so that OPM could contact your physician. But again, it's best if you request them ahead of time, look through them, take out what is important, what should be shown, and what supports that your condition exists and is disabling, and then send to OPM along with the package. Now, you do not have to submit it all from one doctor. So I get a lot of questions about some of this, what doctor's the best and who you should go to in this and the other thing. If you see 5 different doctors, as we all kind of do nowadays with the specialty of how medicine is handled, you don't have to just get a doctor from your PCP, from your general physician, a letter. You can get a letter from your neuropsychologist, from your chiropractor, from your surgeon if you just had back surgery. You can do all of those things. You can go to all of them and ask them for statements specific to the disabilities that they can speak to. So you don't need your surgeon who just did back surgery to talk about your depression. You would want a letter from your counselor, from your therapist, from your psychologist, and from your surgeon describing, this condition that he just treated and this condition that you're currently being treated. If you do that, the stronger applications are ones that have it where each doctor is able to speak to the disability and how it affects your position. Why can you no longer work in your position because of your depression? Why can you no longer work in your position because of your back surgery? What kind of limitations can they speak to? So if you can get letters from your multiple doctors, that's actually better for you. And they're able to speak to specific things for those conditions versus just asking, collecting all of your records and having your general physician speak to it. If they can, that's great, but just want to make clear it's not you're not like required to get it from one versus another, or it's always better to have whatever doctor can specifically speak to that condition to speak to it, to write a letter, to provide records. And OPM will consider it all. Okay, if we can go to the next slide. So this is one thing that I want to highlight because COVID has really changed how a lot of applications can be processed. There was a period of time where OPM was accepting no paper applications. Everything needed to be done electronically. So what has changed somewhat is that you don't have to send in the original paperwork, but you do have to still hand sign the forms, the documents. So they will not accept an electronic signature. This means Adobe PDF electronic stamped signatures. This means signatures where even if you're, verifying that it was you as part of like Panda Docs or DocuSign, any type of signature like that, it will have a rejected form. They will ask you to re-sign it. It's a wet signature, essentially. So the one thing that I have seen accepted are signatures where it's like on your phone and you're signing it with your finger or your a stylus. Those kinds of signatures may be accepted just because it looks like an actual handwritten signature. But otherwise, you do need to fill out the application. It can be typed in, but you need to print it out, hand sign it, and then scan it back in. But you can send it to OPM electronically. It's best to send it in multiple ways, but if all of what you have available to you is, say, fax, as well as email, you can do things like that. But again, you have to wet sign it. You have to hand sign it. You cannot electronically sign it. I discussed this a little bit before. If you're still employed, the entire package you complete must go to your agency's HR department or whoever they designate. If you are no longer employed and it's more than 30 days, you can apply right to OPM. This can get frustrating in the standpoint that if you are still employed, waiting for your agency to process it through, to fill out the forms, to do everything, you really have to be actively engaged in monitoring and following up and making sure that they do it in a timely fashion. As most of the individuals who are probably interested in this webinar know, the federal government does not move quickly for anyone. So if you are the bee in their bonnet, if you are bugging them incessantly to fill out things, the better it is for you because they just don't want to hear from you anymore. So you really do have to keep up with them if you are still employed to make sure that they fill out those forms in a timely fashion. As part of the application, you do have to apply for Social Security disability. Really important here is you do not have to be approved for Social Security disability. You just have to show proof of application. So what is sufficient for this is applying for disability through Social Security, printing out the email confirmation, printing out the initial application, anything like that, that's included as part of your application package to disability retirement, and OPM checks off a box. So they don't have to see that you are approved. They don't have to know that you're approved until you are. If you're denied, it will not necessarily hurt your application because, like I had said earlier, the regulations, the requirements for the two are very different. There's some overlapping, but for Social Security, say, just to put a little meat there, Social Security is about your ability to work anywhere. For disability retirement, it's your ability to work in that position that you formerly or currently hold. So for Social Security disability, you just have to apply for it. Our firm does not handle disability through Social Security. It's a very, very niche area of law. Most firms that do Social Security disability applications, that's all they do. We do have referrals and everything that we can provide clients, but we don't do that specific area. There's also differences in how retainers and things like that are managed by Social Security Administration. So for SSDI though, if you are approved, you must inform OPM as soon as you can. Whether you're sending in the approval letter, you're letting them know specifically what your benefits are, you need to let them know, and you need to save the receipts of when you do that. The thing, and we'll discuss when this is, how this is computed, but Social Security disability will be offset for a certain number of years from your disability retirement. So for the federal government, your disability retirement may be subtracted from by the Social Security benefits you are receiving. So that's why it's important to let OPM know, because when they're providing or calculating your benefits, you want to make sure that they do it properly and it doesn't create any kind of debt where they're overpaying your benefits in any way. The interplay for workers' compensation and disability retirement is important as well. Sometimes people tend to wait until workers' compensation runs out to apply for disability retirement. I do not recommend doing that, especially if you are no longer employed, but you're still on workers' compensation. You should apply for them both at the same time if you can. Some of the evidence, the medical documents might overlap. Obviously, if you can't be accommodated, you're going on workers' compensation. So you will want to apply for them both at the same time. You can be approved for disability retirement while you're on workers' comp. You get the choice on which one you want to continue with. If you continue with workers' compensation, but you have approval for disability retirement, you could, at the end, say workers' compensation runs out or is terminated, you could request and ask OPM to start your disability retirement benefits. If we can go to the next slide. So for how it is computed, ultimately your annuity, whatever retirement you're applying for, it is ultimately going to be determined based on your age and the amount of service. So in this slide, we did include the link, which goes into detail on how each specific retirement annuity might be calculated. But for disability retirement, it is going to be as of, the date that you are applying your benefits. You could earn them as of the date of last pay. So if you have been removed as of August 24th of 2024, you are approved for disability retirement December 31st. Your benefits will be calculated as if you had retired under disability as of August 24th, 2024. So you would be getting back pay of benefits. And that would obviously affect when your 12 months after the first 12 months, they would calculate it all from that August 24th, that date of last pay. So for disability retirement, you do not have like a consistent annuity. It does change between the first year versus every year thereafter, how your benefits are calculated. For the first year that you are on disability retirement, it'll be 60% of your high 3 average salary. From this, as I mentioned with SSDI, if you are approved, there will be 100% offset. So what this means is if you are getting 60% of your high 3 salary is $4,000 a month, you get $2,000 in Social Security disability. You will then get instead $2,000 from your FERS disability retirement and $2,000 from your Social Security disability. So that's where I'm saying that it's important to make sure OPM is aware as soon as possible that you are getting Social Security disability. For the next 12 months and then every year thereafter that you remain on disability retirement, your annuity will be 40% of your high 3 average salary with only a 60% of your SSDI offset. One thing to keep in mind with eligibility, other than the 18 months of service, is going to be if you are eligible for an immediate retirement at any point. So if you're over the age of 62, or you're eligible for possibly any other type of early retirement, disability retirement is probably not going to be approved. simply from the standpoint that your annuity is going to be much less under disability retirement. But if you are eligible for an earned annuity, a regular annuity, they're going to approve and process that application. For individuals who are, say, considering disability retirement and they're 42 years old, you could feasibly, if your condition continues to be debilitating, you could feasibly be on disability retirement for the next 20 years until you reach 62. Each year that you are on disability retirement, you are earning service year credit. So if you have 5 years going into disability retirement and then you have another 20 years on disability retirement, at the end when you're 62, you could have 25 years of service credit that would be used in computing your regular immediate annuity once you come of age. For the high 3 salary, and there is a lot of confusion and misinformation here. When you go on disability retirement, you are essentially frozen in time. So if you are on disability retirement as of August 24th, 2024, you are a GS 15 step 1. You will continue to be a GS 15 step 1 for the next however many years you are on disability retirement. You do not get step increases, you do not get credit like for overtime or things like that maybe if you had continued working that you would earn. You are only eligible for COLA, cost of living increases, that will affect your salary for each year thereafter. So if your salary in 2024 is $100,000, each year it goes up approximately $2,000 for COLA. You would get credit for all of that. So your high 3, when it comes time for regular retirement, could be affected, could be adjusted, because they will give you the credit as if you had continued working, but they will not give you, step increases, grade increases, things like that. That maybe if you, in the real sense, if you had continued working, maybe you'd be eligible for. They don't do that. So very important point, your high 3 will only be affected by COLA increases while you are on disability retirement. If we can go to the next slide. So timelines. So OPM, when you apply for disability retirement, it can take anywhere between, it's a mighty big range, but I've seen applications approved within 2 months. And I have had clients wait for more than 8 or 9 months for a decision. This is from the time that the application is in OPM's hands. So this does not include the time in which it takes for your agency to process the forms. This does not necessarily include the time in which it takes you to complete forms, or your doctors to respond and provide medical records. So it can be a long process. The things that are in your control are obviously your requirements. So you can do those in as little as 2 or 3 weeks, depending on, the individual. But the other things that you're waiting on obviously are outside your control. Like I said, hammering them, being a bug, being a pest, following up, making sure you're on top of it is very important, and making sure other people stick to the time frames. OPM, they're going to take as long as they take. I have called, I have bugged them, I have bothered them. OPM will do what they want. So keeping in mind and working it into your framework, your timeline on what you expect for maybe where you are in life, what you can kind of project out and plan for the future. OPM can take anywhere between 2 to 9, 10, 12 months to process an application. Obviously, the more complete the application is when you first file it, the more seamless the process is probably going to go. But there's also the element, what specialist is going to get it? How are they going to review it? Do they have other questions? Are your doctors, are they as complete as they could be? Those medical records, things like that can affect that process, that timing. But eventually you will get an initial decision. How OPM terms them is initial decision and a final decision. So when you get an initial decision, that will trigger an appeal internally through OPM, which is called a request for reconsideration. You will have 30 days from the date of that initial decision. And I say from the date of the initial decision because OPM will send these initial decisions through snail mail, through the mail. They will not email them to you. They will not send them up to this new portal that they have going on for retirement. They will mail them to you. So that means if the decision is dated August 1st, it is very possible it might not get to you until August 10th. If it gets to you August 10th, check the date of the letter, check the date and save the envelope that it came in. It's possible that OPM dated the letter August 1st, didn't mail it until August 7th. Save everything that you get. That helps you establish when exactly you have to request reconsideration from OPM because you want to be timely. OPM at any point, if anything is untimely, they can simply deny a review of it because you didn't file it on time. Or they'll ask you to jump through hoops to explain why you filed it when you did. So keep track of everything, save everything that you get from OPM. Keep in mind the 30 days. So as part of a request for reconsideration, you have 30 days to make the initial request. You can request another 30 days to provide additional evidence. So it does give you possibly up to 60 days from when you first get that letter to get more medical documents, to try to get more details from your agency, to try to write up additional statements, anything that could support the reasons for the denial in the initial decision from OPM. If you file the request for reconsideration, processing times again kind of vary. I've seen them come back within a couple months. Usually they're a bit faster than the initial decision. It does go to a different department at OPM, so it is a reconsideration branch as opposed to the initial review. They will look to see if your documentation that you submit as part of the reconsideration, if it addresses essentially what OPM found was missing in your initial application. If you are still denied on that request for reconsideration, that is when you would get the rights to appeal it outside of OPM. So for federal employees, the Merit Systems Protection Board, or the MSPB, is an administrative agency, a separate agency that has been given sole jurisdiction to hear these cases. So you're not able to take it into federal court yet. That's a possibly a appeal option you have later on, but you have to. The only appeal right you have is to take it to an administrative judge at the MSPB. This again has a 30-day deadline. If OPM makes you jump through hoops for timeliness assertions, the MSPB very rarely makes exceptions for anything untimely. So anything over 30 days from the date that you received the letter, the final decision from OPM. You will have the opportunity as part of the MSPB process. It's essentially a litigation process. So putting a little bit more meat there as well. The MSPB is, for all intents and purposes, a court that you are essentially suing OPM for their incorrect decision about your disability retirement benefits. And you want the judge to award you the benefits. You want the judge to say OPM must find that you are eligible for disability retirement and must pay you the benefits and any back payment of benefits that might be owed. So the judge would have the authority to do that in this appeal process. So as part of that litigation, you would have discovery, you would have motion practice, you would have a hearing about whether or not you are eligible for disability retirement. And you can introduce more medical evidence, new medical evidence. You will have the opportunity. These appeals can be, again, very lengthy processes. So you would have the opportunity to get more medical evidence if needed. So for the appeal, you do have, again, multiple options on an ability to try to get more information as part of that. You'll have the option to work with OPM. It's going to go to a new branch. It's going to go to a different branch from the initial review and the request for reconsideration review. It'll go to a new representative. And there are times where you will have a good representative and you will be able to say, what do you need? What can I get you? What are ways that I can kind of clear up misunderstandings with my application? You can essentially negotiate with them in settlement. If the judge at the MSPB rules and says that you are not eligible or makes a decision that's not in your favor, you would have another appeal process. You would be able to request within 30 days of that initial decision by a judge, you would be able to take it to the board, which is a 3-panel team. You will be able to take it to a 3-member panel, I should say. You'll be able to make an appeal to them. It's called a petition for review. And that is just at that point, it's on the briefs, it's on the record. So there's no additional hearing, there's no additional evidence that's necessarily being submitted. You're asking the board to review what the judge has found and say, you know, what he missed, what was incorrect, what was wrong. And from there, you would have them review whatever your argument is, and then the record in its entirety, and they would make a decision. If that appeal comes back unfavorable, you would also be able to take it to, and you would be able to do a final appeal essentially to the Federal Circuit Court of Appeals. This is a federal court. This is outside of the federal government. Essentially, it's an actual court. You would file it in. Similar setup as a petition for review, but you would be assigned obviously federal court judges. They would be looking at the record, any briefs, and you'd get the possibility of a 10-minute oral argument in front of the court, but no hearing, no additional testimony, very rarely additional evidence at that point as well. It is also a much kind of higher standard, and keep in mind at that point, you're dealing with federal judges. You're not dealing with administrative courts and OPM representatives. That suit would be against, you'd be dealing with attorneys and things of that nature. So if we can go to the next slide. So things that an attorney can help you with, things that I regularly help clients with as part of this process, is filling out the application. Depending on your disability, this could be a very overwhelming process. The forms do require personal information, so obviously I'm not going to know your bank account information, but I can certainly help you fill it out. I can walk you through what's needed. I can help you find resources to get that information. It's very much where we kind of help you through the forms as much as we can. We also, though, apart from the forms you're required to complete, we also help prepare a statement, a narrative statement that maybe you, a family member is willing to write. We might give you pointers, we'll draft it up based on kind of initial feedback, basic details from you about your disability, how it affects your life, give you kind of a format to fill in information and go from there. We'll also work with the agency to complete their side of the forms. So the only thing generally we might need from you is an initial HR contact, and then we take it from there. You'll be included obviously in attempts to get those forms, but generally speaking, we can get those forms, work with your supervisor, work with your HR, work with say the accommodations office to get those forms, send the application in for your on your behalf. Make sure that the agency is filling out the forms and sending it forward, trying to get copies of it, you know, obviously to make sure that we have backups and we can send it to OPM. I'm always reviewing applications to make sure that all of those specific words that OPM might be looking for are included in the statements, in the forms, in the doctor's letters. A lot of times if your doctor's willing to work with us, we'll draft up a form letter. We'll send that letter to your doctor. All he or she needs to do is fill in the blanks. You know, we can pretty much, you know, figure out what your position essential functions are, what, you know, generally how your disability affects you based on all the information you've already provided. And then we can draft up a letter and get that over to them to plug in the rest, you know, in their own words. How would they describe this? And we'll leave comments and notes for them to do. So we regularly do those things. I'm tracking your timeliness. So you don't have to worry about the 30 days, when the 30 days is, where the letter is, what's going on. Obviously an attorney, that's their responsibility. They're tracking that for you. They're making sure everything's done on time and they're the ones responsible for, following up, making sure that people are responding, doing things like that. When you get to the MSPB, the Federal Circuit, there are a lot of requirements for what goes into a pleading, how the pleading is filed, court requirements, communications with the judge, communications with OPM or a representative. We would do all of those types of things on your behalf. The other thing, obviously we're talking to OPM, we're trying to engage in settlement. We're trying to resolve it as soon as we can, right? We're dealing with your life here. We're dealing with the risk of, healthcare being lost. And that's very important for someone going through disability retirement. So we want to make sure that we can resolve your case as soon as we can. It obviously does require, cooperation from OPM, but we want to try to resolve it. We want to nip this as close to the bud and get it finalized for you as we can. So if we can engage in conversations with OPM, sometimes the representatives can be very straightforward. I don't see any of this in their records. What can you get? Can you get something to address it? And then, we're just crossing T's and dotting I's and moving on. So we can assist with all aspects of that. And it really depends, on the individual. Obviously each individual's position, each individual's disability is going to affect them differently. Some people have support to be able to do specific aspects of this process and assist them. Other people don't have that. So it's really at any point an attorney can assist you and kind of take some of that pressure off. Because that would be the whole point. You're hiring someone to help you, not to cause you more stress. So with that, I think the next slide is going to be questions, and I know that there are a couple questions ahead of time. So there was a question about are intermittent or part-time employees covered? They're not. Well, it depends. A lot of it is based off of your creditable service. So intermittent, part-time, the years of service that you earn, the credible service that you earn is going to be different than someone who's full-time. So it might take you longer than 18 months if you're part-time, if you are intermittent, to reach 18 months of credible service, but that's your requirement. If you are granted disability retirement, how does the government verify your income if you get another job? So this is a good point, and there's a couple things I want to say in addition to addressing just this question. For disability retirement, you are required to essentially recertify your disability if it's once a year. After, if it's, OPM, probably it'll be more like 2 to 3 years. They might send you a questionnaire to fill out. They'll want, an updated medical letter saying, the condition continues to exist in the same way. So when you are, when you're getting those questionnaires, it can be as simple as, submitting, nope, nothing's changed, moving on. OPM will check the Social Security reported wages. So I've often seen individuals come with, OPM has printed out a screenshot of what Social Security has been reported that your earning is. They'll go by your W-2s, every year. They won't do it multiple times a year or something like that. You will have to make sure that your income stays under the 80% salary cap. So if you are, if your disability retirement benefits equals $100,000 a year, your 80% cap for any other employment will be $80,000. So you'll want to make sure that if you are getting outside employment, that you stay somewhere under 80,000. So that it's important for you to track, because if you exceed the salary, you could temporarily lose your disability retirement benefits until your salary comes back under that cap. The other thing to keep in mind with continuing to be on disability retirement is that if you go back to work for the federal government, that can sometimes automatically take you out of disability retirement. There are specific rehiring regulations and things that can be done, and how you're re-entered as an employee. But it's a very, very It's a very nuanced. So just really, if you're thinking about going back to work, be aware that there's probably a significant risk that you could lose disability retirement benefits. The other thing is the type of employment you go out and find. So if you're getting disability retirement benefits because you are a former police officer for the Department of Veterans Affairs, if you go and get a security position at, the local hospital, the chances are the essential functions are very, very similar between those two positions. And if OPM learns of those that new position, that's where you're now working, it may be harder to justify that you are still eligible for disability retirement benefits. So you could lose the benefits for there as well. A couple people did ask about the difference in the process for LEOs or law enforcement officers and just regular employees. There's not much of a difference. It just might come down to where you're getting medical records, the accommodations that are available, or that kind of process. So there might be just a couple steps within some of these requirements, but the requirements themselves apply to all individuals who are applying for disability retirement from the FERS. Let me see here now. There are a couple additional questions. Hold on. For back pay of benefits, is it received as a lump sum or a calculated installment? You will get, so what typically happens if you have a situation where you are, approved and you're no longer working or you weren't in a working status, you will have OPM, they will calculate what your monthly annuity will be. They will give you two payments. They will give you a lump sum payment of what any back payment or of benefits that are due after that calculation. And then you will receive a payment, generally in the beginning of the month, the first of the month, for that next month. So you should get two checks or two direct deposits of that, but they will not like break it up and say, okay, we owe you $30,000. We'll over the next 10 months we'll pay you X amount. They don't do that. They do one check for all of what's owed, and then the next check will be what you will start getting each month. We do not, so for disability retirement, we do not do flat rates for any type of retainers. If you want to do a consultation about your specific case, we can do things like that, and we describe how we do it. But we do, as our firm practice, we do payments, and then it's based on an average cost for these types of cases. Health benefits. So can you lose your health benefits if you go over the salary cap? So if you are no longer on disability retirement, yes, it's possible. You can obviously have your disability if you're just going over the salary cap. If you lose eligibility that way, it's kind of like a pause button. You can apply as soon as your salary comes back down. You can apply and get back into disability retirement and go forward from there. Losing eligibility in other circumstances, it's a little bit more complicated from that. Any of these you can obviously challenge. There is a question, do you have to submit to a medical exam or a physical by a government doctor? This is different. So this is a clear difference between Social Security and disability retirement. You are providing all of the medical records, all of the information to OPM. Social Security, they may order, or workers' compensation, they may order you to go to a specific doctor to get evaluated. Disability retirement, OPM does not have that type of authority. So it would be more of if, say, you did not have the medical records to back up that you had post-traumatic stress disorder. This is a situation where sometimes we may figure out, is there a doctor that you could go to get a psychological assessment? So you're going to them specifically for that purpose. You're paying for that doctor of your choice to perform an assessment of that nature. But it's not, the OPM can't require you, the federal government cannot require you to go to that specific doctor and get that assessment done. That would be more in a discussion with your attorney or something of that nature. What is missing from my record? What can I get? What would help? Where could we go? And we'd go from there. So that's more of on a voluntary basis, whether you submit to additional medical testing or whether it would help your application would be really the goal in doing something like that. The last question here, and then I'll leave you with, if you lose eligibility due to salary, will you still get regular retirement at retirement age? Yes, I mean, once you hit 62, and you have more than 5 years of creditable service, you will get an immediate retirement, notwithstanding, what other, eligibility for what that regular retirement is. So this would not, if you get off of disability retirement, so long as you have, in most cases, more than 5 years, and you hit whatever minimum age requirement is there, it will not prevent you from regular retirement. So I think that I addressed every question here. So I guess I'll leave it there, Taylor.
Thank you everyone for joining today's webinar, and thank you Amanda for presenting. Our contact information is on the screen in case you want to contact us, but I hope everyone has a good rest of their day, and thank you for attending.